I've met most of you. If I haven't met you, I'm Anna Cunha. I'm one of the partners at Angus and Terry. I'm here with Lance Stewart. We have a presentation for you today, and then we'll also open it up for questions. But we'll be providing a copy of this presentation as we always do. If you do have it, it's for your own personal reference only. Please don't share it with board members or anyone outside of Collins. This is not legal advice. It's just general guidance for you. And if your association needs specific legal advice, please reach out to their general counsel. And if they don't already have general counsel, reach out to us. You know that we are a full service law firm specializing in HOA law. So we have a general counsel department and we work with you, most of you on that. And we also have a construction defect team that works on under 10 SB 800 claims for newer associations. For new clients, if your association doesn't already have general counsel or want to switch to a new law firm, we pride ourselves for being one of the most responsive, if not the most responsive law firms in the industry. So please consider us. We do offer special rates for the first 6 months for our new general counsel clients and also a complimentary Zoom training. And some of you have taken advantage of those specials. So today we wanted to talk to you about fair housing laws. A lot of you know a lot of this, and also, but it was mainly because there was a new case, a ruling where the judge came down and issued a $7 million verdict against the association, the management company, and also employees of the management company. So it's really worth talking about, you know, best practices. It's a good reminder for some of you. And then if you are newer, you know, it's good to understand the issues that may come up that you should definitely involve legal counsel in. So I'll be talking mostly about race, but it's also in the same analysis and same thing that deals with other types of discrimination, other protected classes, and then we'll talk about Lance will talk about disability discrimination a little bit, and requests for reasonable accommodation, and then we'll talk to you about that lawsuit. And the ruling on that, and also some examples that you may have experience with. But the general takeaway that we hope you walk away here with is these are not issues that you should ignore. They're very important. It is one of those things that you would want to get legal counsel involved in quickly. It's important to, even though you think you may know what the steps are, to at least work with legal counsel and get guidance on those steps. And most importantly, documenting the steps that are being taken. You know, you should let the board know. I know they don't want to spend money on attorneys, but this is one of those where it's worth spending money on in the front end rather than dealing with threats of litigation, actual litigation, or complaints from the DFEH or Civil Rights Department about discrimination. All right, so basic concepts here. The association is considered a housing provider under state and federal laws. And the discrimination that is specifically prohibited is discrimination based on protected classes. Those are the categories that's listed in the law, not just any type of discrimination. For example, some may say that the association discriminates against tenants versus owners. That's not a protected class necessarily. So we're talking about the categories like race, color, ancestry, national origin, religion, sex, gender, age, familial status, disability, source of income, and source of income includes, Section 8 housing or residents of Section 8 housing. So there's 20 in California. There's a less categories in federal law, but that's just something to be aware of when there is a claim that somebody is being discriminated against based on something. You'd want to check with legal counsel to see if that's even a protected class if you're not sure, and then work with counsel on dealing with those specific complaints. And if, and just so you know, if there is an allegation of discrimination within the premises of the community, whether it's a complaint from or against a homeowner, a tenant, a vendor, an employee, or even guests. But if it takes place, the events take place on the premises of the association's property, the association as a housing provider has a duty to investigate and take the necessary steps, whatever that may be. And that's different in different situations. But at the very least, they do have a duty to investigate, and even the investigation part could look very differently depending on what's being alleged and by whom and against whom. So definitely take that seriously, even if it's from someone who may not be that credible. Those are the dangerous people because they can complain to the DFEH or CRD. But any complaints related to discrimination, definitely get counsel involved. So there's a lot of laws that talk about that are part of what we call fair housing laws. We talked to there's federal laws, the Federal Fair Housing Act and HUD regulations. That's codified in the Code of Federal Regulations. And then there's also California laws that kind of mirror, but slightly different from these bodies of law. So there's 3 different areas of law. So you don't have to know exactly what these are, but just know that there are a number of them that come into play when it comes to discrimination, and they do apply to the association.
This is the part we're going to quiz you guys on later.
Yeah. It's very dense, and a lot of it are related to employment, but there's a lot of the laws we care about are for the housing providers. You'll often hear someone say, well, under the ADA, the association needs to do something. And just so you know, for most associations, the ADA, the American with Disabilities Act, doesn't apply to them. Usually the ADA, but the ADA does apply to facilities open to the public. That's why restaurants and parks need to be ADA compliant. But don't just automatically assume your association isn't subject to it. I had an association that had a public bike path that the city had an easement for. So it was a public bike path that ran through their property. And sure enough, somebody who complains about everything complained about the slope of that bike path, that it wasn't ADA compliant. And unfortunately, they did need to comply with that. So but for most associations, the pools and and things like that, the facilities are mainly for residents. So it's not open to the public. So the ADA wouldn't apply to them. But just because the ADA doesn't apply to an association and somebody uses that term incorrectly, it doesn't mean that they don't have a legitimate claim or a basis for either a discrimination claim or an accommodation request. So even though that may not apply, you want to just really look into what they are alleging or asking for, because just simply dismissing that ADA request as irrelevant to the association can get you into trouble. So the Federal Fair Housing Act, the FHA, this is the main area of law, and you just need to be familiar with the concept that an association could be held liable for its own actions, the actions of its employers or managing agents, or also for not doing anything. So this is the part of the law where it specifically says, I think that's obvious, if the association is engaging in discrimination, they could be held liable for that. An example is I have an association where some homeowners are alleging that the board discriminates against African Americans and are enforcing rules governing document violations more strictly against them, and are not taking their requests for repairs seriously while treating other groups differently. So if that is true, then the association would be held liable for those types of actions. Okay, I think I skipped ahead. Sorry. That is. So the other part is associations being held vicariously liable for the actions of their employees, which could be also your vendors, but also actions of management. But of course, you guys wouldn't do this. You guys wouldn't engage. But as the agent, the association can and the board can be held liable for your actions or actions of its vendors. And it doesn't matter whether they actually knew about it. So it's very important that any hint of some type of discrimination allegation, the board jumps on it, because they can't just say, well, we didn't know about it. It's regardless of whether the HOA knew or should have known. So it's the law is very serious about that. And here's the part that most people don't really are not as aware of. It's that the association can be held directly liable for failing to take prompt action regarding a discriminatory or housing practice by a third party. So somebody else is engaging in discrimination. So you'll often hear about a neighbor to neighbor issue where they say their neighbor is doing certain things because of their race, their gender. Those are the more common ones. Because they have kids, that's familial status discrimination. And I see a lot of boards, take a step back and say, we don't want to get involved. That's a neighbor to neighbor issue. You deal with that yourself. That's where you have to step in and advise them or tell them to work with legal counsel on this issue, because as a housing provider, the association absolutely has to get involved, because they can get in trouble for things that the other parties are doing. Even if it's a tenant, it doesn't matter if they're not a member of the association. I dealt with one involving a guest of a kid. Actually, they were kids. There were kids saying bad things, and then somebody complained, that homeowner complained to the DFEH, and they spent a lot of money on legal fees responding to that complaint, because at that point, the manager, not from your company, not from Collins, the manager thought they didn't have to get involved because it was a neighbor to neighbor issue, and it was some kid's friend, a tenant friend. So very removed, and it was a kid. And so they didn't feel like they had to do something because, hey, kids say bad things, and they don't even live there. So in that situation, the association definitely had to take some steps, and the investigation could be simply looking into things and talking to the people who might be involved. But the law does take into account the association's power to correct. So in that situation, the association couldn't have called that kid to a hearing and imposed fines on them, but they could have done other things to talk to the homeowner, talk to the tenant, raise these issues and basically make it clear that the association, that's not acceptable behavior anywhere in the association. So as far as for best practices for dealing with discrimination allegations, whether or not you think they have merit, you should definitely take it seriously, work with legal counsel on all the steps, conduct an inquiry into the complaint, Sometimes it's necessary to hire a third-party investigator and do like a full investigation into the issue. And sometimes it's just a matter of interviewing people who were involved and asking for their side of the story. So it depends on the situation. Talk to witnesses, that's important. And the most important thing is you document the evidence, because a lot of times there's nothing will come out of it, but later on you may get an inquiry from the Civil Rights Department or the DFEH, and they just want to know how the association handled it. So having that documented is going to be important. Sometimes you will see something there. Maybe it doesn't rise to the level of discrimination, but there is likely a nuisance violation. So you can call the responsible party to a hearing, and then go through that process of the hearing and violation process. And any determination by the board, whether, after looking into it, and they're entitled to take into account the people's credibility, their history with the association, things that were said, and maybe things that were misunderstood. They should absolutely take everything into consideration, take the big picture into consideration, and make a determination whether they believe there was, in fact, or could be discrimination. So legal counsel will guide the board on that. Ultimately, it's the board who makes that determination, not management, not legal counsel. It's the board. And the important thing is to document that process. All right. Disability accommodations, Lance.
All right. Good to see everyone. One of the biggest problems with all these issues is the knee-jerk response of boards to say, I don't buy it. Somebody says racism, like Ann was just talking about, the board says, I don't buy it. Somebody says I have a disability, the board says, I don't buy it. I don't buy they have a disability. When we're talking about disability accommodations, the two biggest problems are the board saying, I don't buy it, show me the disability, this person's walking around just fine, they don't seem to have anything wrong with them. Excuse me, I lost my train of thought for a second. I completely lost what the second point was, guys. I'm so sorry. But as Ann was talking about, the point is to take these things seriously. And I remembered what the second point was now. Thanks for keeping with me, everyone. Boards tend to say, I don't buy it. And they tend to say, won't this create a precedent? Giving disability accommodations can be the easiest thing in the world if you do it right. It can be the biggest problem in the world for the HOA if it's done wrong. What you're doing is creating an exception to the HOA's policy. The homeowner or the resident says, guys, I have this condition. It sure would make me a little bit more comfortable in my home if you granted me this exception to the governing documents. The governing documents say I can't do this. I'd like to do it. Please let me do it. The obligation for the HOA is to say, yes, you can. That does not create a precedent. It doesn't change the impact of the governing documents for everyone else. It just means we're creating an exception for that person. The governing documents stay in place as relates to everyone else. When boards say, I don't buy there's a disability, or what about a precedent? Those are exactly the wrong way to be thinking about these things. We need to move them away from that way of thinking about these things, and we're talking about the right way of thinking about them. So the point of this part of the law is to ensure equal use and enjoyment of homes for everyone. A medical condition shouldn't prevent you from having the full use of your home. In the simplest terms, there are two basic obligations that are basically the same obligation. One is to grant exceptions to the HOA's policies in deference to somebody's medical conditions. The CC&Rs say you have to have hardwood floors, you can't have carpet or whatever. We're going to grant exception to that. The second one is to allow residents to modify their own property and possibly limited portions of the common area at their own expense to accommodate their medical condition. Those are the two big things, but we're almost never talking about the HOA taking on costs. We're almost never talking about the HOA building things, modifying things, changing things. We're almost always talking about either an exception to HOA policy for that person or allowing them on their own dime to make a change to their home. Okay. The law defines disability as a physical or mental impairment which substantially limits one or more major life activities. And there's some citations there for some of the things that we look at to understand how that applies in any given situation, but that's the basic idea. I have a physical condition, I have a mental condition. that makes basic day-to-day functioning a challenge for me. And that's why I'm asking for the HOA's help in changing some aspect of my home. Usually, we're almost always going to say granted. It's an exception to the policy, just granted. There are some circumstances where it's appropriate to not to say no, but to figure out some alternative. You're never going to say no, and we'll talk about that more in a moment, but there's some circumstances where you need to figure out an alternative to what the person is actually asking for. So the big one is if granting their accommodation would create some sort of undue financial and administrative burden to the HOA. We've got a condo building, you want to change some part of your unit, that would actually affect your neighbors. We can't do that. Let's figure out what else we can do to make you comfortable in your home. If it means a fundamental alteration of the HOA's program, if it's going to create a direct threat to the health and safety of others, a significant risk of bodily harm, we're not going to do that. We're going to figure out an alternative. Or if it's going to cause substantial physical damage to other people's property or to the common area property, we're not going to do that very thing you asked for. We're going to figure out an alternative. But if it's not under any of those categories, then generally what the board should be doing is saying, yes, you get your accommodation. Moving on. 3 big issues that we're talking about. Everything that we deal with comes back to these 3 issues. When somebody's saying, I have a disability, I want an accommodation. Number 1, is there a disability? I'll talk about that more in a moment. What is the accommodation they're asking for? And what's the relationship between the disability and the accommodation? Note, we are not asking, what is your disability? What is your diagnosis? What is your prognosis? What's the severity of your condition? Give us 500 pages of medical records. Have a doctor sit and interview with us to prove that you have this. No, none of that. Okay. It's very, very simple. Something showing that there is a disability. And this is why there's some nuance here. And this is why you want to have counsel involved, because asking the questions that you're allowed to ask is very slightly different from the questions you're not allowed to ask. But what we're looking for is something showing that there is a condition, and here's the accommodation you want, and what's the relationship between those things. So you might have a doctor's note saying, not detailed diagnosis, but this person has a respiratory condition. They have a mobility condition. And so I suggested that they do X and Y and Z to their home. Please let them do that. That's the level of information that we're looking for and that the board's entitled to know. You're not going to probe into details about the person's medical confidential information, just this basic level of information. And understand too, it's relatively easy for the person in question to show these things. A lot of times boards think we need a doctor's note. A doctor's note is great. If you have it, then certainly you should stop the inquiry and give them what they're asking for. But it doesn't have to be a doctor's note. It can be a note from anyone or information from anyone that's in a position to know what's going on with that person. It could be a family member that's taking care of them. It could be the person themselves. If you get an email from a homeowner or a resident saying, I have this condition, I need this exception to the HOA's policies, that might, depending on the circumstances, be enough where the board is obligated to grant them that accommodation. So the information that's required is relatively simple. You want to get counsel involved right away and make sure that you're processing that information properly. So best practices, get counsel involved right away. If it's a request for an exception to the HOA's policy, you're generally going to err on the side of granting that. Why? Because it costs the HOA nothing. Okay, we're talking about a homeowner saying, in essence, I'm uncomfortable in my home. Here's this part of the CC&R that says I can't do this. It sure would make me a little bit more comfortable in my home if I could. Please let me do that. It generally costs the HOA nothing to do it. A lot of boards say, I don't buy it. I want to see some proof they have this disability. I want to see proof that they need this particular thing. No, just typically it's not going to cost the HOA anything. Just give it to them. If it's a request to modify their property or the common area, that's where the questions become a little bit more complicated. And the first step is going to be asking them to submit an architectural request. Show us what it is you want to do so we can assess it and assess whether it's going to cause a problem for other homeowners, whether it's going to cause a problem for the HOA. Is there something we need to deal with? Or is it perfectly acceptable? And the other piece to understand here is that sometimes if we are talking about a change to their property or even a change to the common area, the best way of protecting the HOA while granting it to them is going to be the use of a covenant. And I deal with these all the time, where we draft an agreement that gets recorded against that person's property that says they were permitted to make these changes because of a medical condition. We're not going to get into medical detail there either, but they were permitted to make these changes, but they accept responsibility. If there's some problem, that results from them making these changes to their home or to their condo or to the walkway from their parking space to their home, they make these changes, we let them do it, and it causes a problem, that homeowner accepts the liability, accepts the responsibility. That way, you're not getting liability for the HOA in terms of a fair housing violation, but you're also shielding the HOA from liability from something that might result from the changes that person is making. You're going to consult with counsel regarding the appropriate response to what they're saying, including making sure we all understand the relationship between the disability and the accommodation, and whether there is some legitimate concern that what they're talking about will create an undue burden for the HOA. Again, never say no. Never, ever, ever just say no. It's always, let's talk about this some more. If you're unable to grant exactly what they're asking for, the law requires that we engage in what's called an interactive process, meaning let's sit down, let's talk about this. We can't do exactly what you want, but let's figure out what we can do to get you where you need to be. You never just say no. You have a sit down, you have a conversation. We've got a couple right now where we genuinely didn't understand the purpose of the accommodation that was being asked for. You engage in a process, but help us understand how we can help you better. That's the conversation that needs to be happening. And you never fail to respond. You never fail to make a decision. You always are in prompt contact with that person. And a lot of times you're doing this through our office or through counsel. But if there's going to be a delay for any reason, you make sure you're giving them updates in writing, or that we're giving them updates in writing, because delay under certain case law can constitute a denial. You make somebody wait for half a year before you get around to making a decision. For all intents and purposes, you've denied their request. You're in violation of the law at that point, and that's a big problem. So never fail to make a decision, never delay, and if there's going to be a delay for some reason, you tell them what's going on. Okay, why is all this so important beyond it being, generally the neighborly thing to do to grant these requests? With both the discrimination, harassment stuff that Ann was talking about earlier and disability accommodations, the reasons these things are so critical for all boards to understand is that the exposure is potentially enormous. Because the way, particularly the Unrest Civil Rights Act in California is structured, there are several different types of monetary penalties for the HOA if the HOA loses a lawsuit along these lines. A homeowner brings their lawsuit in federal court. The HOA failed to get involved at all when I said racism or religious bigotry or gender discrimination in my development. The HOA failed to do anything, or they failed to grant me my accommodation. If they win on that lawsuit, they get a few different things. They get their economic damages, their out-of-pocket expenses. The HOA wouldn't grant me my request for an accommodation, so I had to buy something else, some thing off of Amazon that didn't really work that well. I get my damages for that. Non-economic damages, what we usually call pain and suffering, they get that. If they have no out-of-pocket damages, they get a minimum of $4,000 per violation in actual damages. There's also case law to suggest that that number can be done on a daily basis for each day that the request wasn't granted or each day the HOA failed to act. There's case law suggesting that that could be $4,000 per day against the HOA. $4,000 a day adds up really, really quickly. Then whatever dollar amount the damages are, out of pockets, non-economic, $4,000 per day, whatever it is, that dollar amount can then be tripled. So now we're easily, in a garden variety, very simple case, 6 figures in damages. They also can recover their attorney's fees, where the court is saying, in essence, okay, HOA, you failed to do what you should have done here. This person had to go off and spend $135,000 in a lawyer to sue you and go through depositions and discovery and motions practice and everything else. Now, HOA, you're going to pay that person back their $135,000. That's separate from the damages. So we have another 6 figures. And the court can award punitive or treble damages, which has nothing to do with their out-of-pocket expenses, nothing to do with their pain and suffering, and it's just a dollar amount for the point of punishing the HOA and making an example of the HOA, like the $7.2 million that Ann was talking about earlier, and she'll come back to later on, saying to the HOAs of the world, you can't do this. You have to get involved in these situations. You have to grant these requests. So the point is that what should have been a very simple administrative decision for the board from the beginning, yes to this exception to our CC&Rs, suddenly turns into a legitimate claim against the HOA for 6 or 7 figures. Get us or counsel involved right away so we can protect the HOA, protect the board from themselves. All right, speaking of protecting boards from themselves, we're going to give you a couple of examples of what not to do, and then Ann's going to talk about examples of things that worked out a little bit better. Here we have a homeowner who said, in essence, I have a mobility condition. It doesn't really work for me to go up and down the 2 flights of stairs to get to the on-site laundromat. I would like to install a washer and dryer in my condo. The governing documents say you can't do that because it's going to put a strain on the plumbing. The homeowner has a doctor's note. At some point early on, it seems like we're close to resolving this. We have all the paperwork together, a settlement agreement and covenant that basically says the homeowner gets to do this, but they take on the liability, and the conversations get sort of derailed. They don't come to a close. The homeowner then proceeds to install the equipment without approval. The board doesn't like that. An inspection is conducted with some suggestions about what might fix the situation overall, and is it in fact going to cause a plumbing problem for the HOA? There may or may not have been some issues between the board and the person who conducted that inspection that I won't get into here. The board later determines to call the homeowner to a hearing. Now, bear in mind, throughout every step along the way, we are begging the board to comply with the law. Sometimes boards can't get out of their own way, but they called the homeowner to a hearing, which shouldn't be happening, saying this is an unauthorized installation. The board then asked for a second doctor's note, then clarifying information, a third doctor's note. These are all things you should not do. When you have the first doctor's note, for all intents and purposes, you're done. It might be a legitimate question about whether the particular thing the person wants to do, installing the washer and dryer, creates some plumbing situation for the building, but we're no longer talking about whether they have a medical condition. We're talking about what the solution for that medical condition is. You never, ever, ever ask for a second or third doctor's note. So what not to do. Another one real quick, just for your amusement. They had a homeowner who asked to install an air conditioning and air filtration system in her condo, saying she had a very serious respiratory disease. The board denied the request, saying, here's this portable AC unit we found on Amazon. Why don't you get that instead? No, don't do that. They later asked her to file an architectural application, which is actually fine. That's appropriate. That's what you do. But there are more delays. The homeowner then provides a packet of information, including details on what she wants to install, and a letter from her physician saying she has asthma and COPD, and the physician recommends an appropriate filtration and AC system to help her, breathe in her home. There are more delays from the HOA. The homeowner then submits another packet of information, this time including 2 doctor's letters, the architectural application, signatures from her neighbors saying they don't care what she does, proposals and insurance certificates from 2 contractors prepared to do the work for her, and a personal statement regarding her need for the accommodation, including that she expects to be responsible for all costs. Still more delays from the board. March of 2020, they finally get around to asking for a legal opinion, and they are told to grant the infernal accommodation. The board decides, who knows why, that what this means is they must first amend their CC&Rs before they grant the accommodation. Wrong. No. The whole point, as I said earlier, is you're granting an exception to the CC&Rs. You don't change the governing documents, and you certainly don't make somebody wait for a year and a half process to amend the governing documents to hold a membership vote before you grant them what they need. So there are more delays. The homeowner then retains counsel, sues in federal court under the Federal Fair Housing Amendments Act, the California Fair Employment and Housing Act, and the California Unruh Civil Rights Act, and she's seeking not only the accommodation, but for the board to undergo and management to undergo fair housing training, for the HOA to adopt a fair housing policy. She wants her damages, she wants her attorney's fees, and she wants litigation costs. Ultimately, this settled for an amount in the low 6 figures. Again, if all that had happened was the board in the beginning saying yes to this thing that really isn't going to affect anyone else at all, none of that would have happened. And want to show us the right way to do it?
All right. I get to talk about the goodness, the boards who listen to their managers and counsel and worked with counsel early on. So this is a situation that we recently assisted with, but a tenant just moved into a unit in a condo development and would bring their 2 dogs in the pool area, having them run around, go up to people. And when the owner, who then told the tenant, received a letter from the association about I think it was a warning letter about, animals are not allowed in the pool area. Of course, I bet you guys have this, you've experienced this, and then they came back and say, oh yeah, they're my emotional support and service animals. So they use both terms, which you all know is two different things. They're my service animal and I'm entitled to have them. And, and yes, they can't be on a leash because they need to be able to come to me if I faint or do something, whatever it was for the medical condition. And at that point, the manager, I think that was it. There was a warning letter, and then the tenant kind of went off on Yelp and all those, and put bad reviews against the management company and also the HOA. And so the association asked for help, and that's where, we stepped in and basically facilitated that process, the process where we exchange information. So we drafted a letter about the association, definitely willing to accommodate if they have a medical condition, but we need more information, like what, and this is pretty common when somebody says, is it a service animal or emotional support animal? Because most emotional support animals can be on a leash. There's no reason. It's usually, if it's a service animal, sometimes they do need to function and do certain things where they have to be off leash. So the goal was to get more information. And of course, that tenant never responded, which was a good thing, and started following the rules because there was no information to be provided, no details about what they need their animal to do to assist them with their medical condition. So, as Lance said, don't automatically say no. Everybody knew this was BS, and it was like really just somebody who wanted to have their pet, walking around the pool area. But we didn't just say, no, we don't believe you. We asked for more information. And the good thing was that association authorized us so that we can ask the appropriate questions, because we can't ask certain things about medical condition. So we did ask more questions about what the animals needed to do, and whether there were two dogs, and it was unclear which or both were the service animal, or if we're dealing with service animals versus emotional support animals. Those are the kind of questions that we could ask, and we did ask. So that was helpful in resolving that issue. Another example of a situation I dealt with, this is a condo association where a homeowner had suffered a stroke and now uses the wheelchair. So it's pretty obvious there's mobility issues in that situation. The board, nobody should be asking for medical records. It's pretty obvious what the issue is. But they asked to install a chairlift in the common area stairwell. And some of the board members were like, oh, absolutely, we got to do this. And some were asking a lot of questions or were very hesitant, but they consulted legal counsel. We walked through their concerns. They were basically concerned that other people will use this, children, et cetera, and get hurt. They were concerned that people and delivery people would trip over the railing because it did take up a good amount of space on the stairwell. And they were worried, that after these people move out, that they'll be stuck with this chair lift. And I think at for this association, there was no issue that the homeowner was going to install it and pay for all the costs. So what we did was work with through the architectural approval process, list out the conditions, and one of the main conditions was the covenant that Lance mentioned, which basically, made sure that they will be held responsible and liable if anybody got hurt or there was any property damage that resulted. They had to use contractors that were licensed and install it with the necessary permits. We also required them to lock the chair and always put it on the bottom, and only give, and that they should only have access, because initially I think they said, oh, we can have our neighbors use it if they want. And we're like, no. It was something like, no, this is just for your use. If you want to let other people use it, you need to give them a key, and that's fully your responsibility, not the association's. And then the board also installed signs about the use of the chairlift. So they did the right thing. They granted immediately and timely. We worked on the covenant. They also didn't feel right having to charge the homeowner for the legal fees to prepare the covenant. And I think, and I, how I explained to boards, that's probably something that the HOA should shoulder, because a covenant protects the HOA more than the homeowner. It doesn't do anything for the homeowner, but it protects the association's interest. So it's something that they would want, because then it has conditions that other people will have notice of, like the requirement that it be removed when they sell or permanently move out of their home in the association. And my last example here is about someone, it's a parking situation. You probably have seen this, but this, we were contacted to help with a violation, a parking violation. Somebody taking up 2 parking spaces, but it was because they have a van that had a ramp, and this owner had 2 parking spaces, deeded parking spaces in the community. They own 2 units, so they had 2 deeded parking spaces in the community, but they were not together, and so they needed a place to be able to park their van and have the ramp out, and so initially the board felt like this homeowner was just taking up the 2 spaces. It was basically guest spaces that were first come, first serve, and homeowners are not allowed, or residents are not allowed to use the guest spaces. These people were just doing it without permission. So instead of sending them a violation letter, we reached out and basically, identified that they may need a parking accommodation. And so we started a discussion of what will work for these owners. And so it basically, after that, they had a lawyer. We discussed a solution to their issue, and the board's concerns that these owners were taking up now 4 parking spaces. They're 2 deeded and the 2 guest parking spaces, and that's not fair for everyone. And they recognize that. So we basically switched out their deeded parking spaces temporarily, at least while they were living there, painted the parking spots so that it's designated as reserved, and then mark the other ones as guest parking spaces. We did it through an agreement, a written agreement, and also a recorded covenant, so that if they sold their unit, they would know that it would revert, the assigned parking spaces would revert back to what it originally was, so that they don't have to deal with new parking spaces assigned to those 2 units. So yeah, there are associations who do the right thing. They work with management and legal counsel and come up with a solution and avoid big lawsuits like this one. Lance, do you want to talk about this?
Oh, I'm doing this one?
Oh, okay, I can do it too.
No.
Yeah. Sorry, go.
You go ahead.
Okay. All right. So the lawsuit that we were talking about, this is United States of America versus Aqua 388 Community Association, First Service Residential California, their LLC, and then Rebecca Hawkins, Christopher Harrington. But in this is a big lawsuit that started out with a homeowner, Dr. Adams. He's a homeowner at this association. He was paraplegic and uses a motorized wheelchair, and he received a parking space that was deeded to her when she purchased it. And then she asked for a dedicated spot because her van's ramp, kind of like the situation I just talked about, the van's ramp required a minimum clearance for the ramp, and the deeded spot didn't require it. Instead of working with counsel like we did in that other situation, the manager had denied it. It's unclear whether it was really authorized by the board or the manager being just gatekeeping and making decisions, but the manager denied it and advised that the handicap parking was on a first come first serve, that they needed to use that spot just like all the other handicap residents. And so there were more requests for accommodation, met with the homeowner met with the managers at a board meeting. The HOA's general counsel had provided an opinion, not us, if you can't tell, but the association's general counsel provided an opinion that says that it was unreasonable what they were requesting, and that the HOA couldn't prioritize that owner's disability over the others. So they just said denied. That would be, they said undue burden, all that. But then, and then the HOA, there were complaints from other residents, including this plaintiff in this case, about the misuse and lack of availability of handicap parking spaces in the property. They put out new association rules about the use of those spaces. But then the association was citing Dr. Adams' vehicle for parking in violation of the rules, of those rules that they adopted. And eventually this homeowner filed a complaint in federal court. Before that, a complaint with HUD, the U.S. Department of Housing and Urban Development. So HUD, it's an administrative complaint. After that, there's still requests and still denials of the accommodation. And the association's attorney and the management company elected to have the claims asserted in the HUD and they wanted it resolved in the lawsuit, basically, instead of dealing with that. So they wrapped it in. And in the lawsuit, the jury in that particular situations, and by the way, if you're not aware, juries don't like most juries don't like HOAs. So it's not a good thing going into a lawsuit already. And in that case, the jury awarded $7 million in compensatory damages. And then also punitive damages, which are hard to get. But in this situation, the jury felt that the HOA and the management company were to be punished for what they made this homeowner go through, and denying the accommodation essentially. So there may or may not be an appeal. This is very new, but that's a situation where they did the right thing. They contacted legal counsel, but they were very aggressive about denying the accommodation. And as Lance said, you have to approach this with the mindset of, with trying to grant the accommodation and trying to figure out a solution, rather than just denying it, because it would be unfair. If there were other people who asked for an accommodation, they should work with them and figure out what works, and at least establish that, rather than just saying it wouldn't be fair to everybody.
And P.S., quick note on that, when we talk about emergency special assessments, one form of emergency special assessment we don't often talk about is when there's a court order for the HOA to pay X and Y and Z. That's going to be, unless it's appealed, and possibly even if it is appealed, that will now be an emergency special assessment that every homeowner in that HOA has to pay for. Yeah.
I don't know what type of insurance coverage they have, but insurance definitely does not cover punitive damages. So there may have insurance coverage for the other things, for the main verdict, but definitely not the punitive damages.
Yeah. So general tips: don't shy away from these things. A lot of boards, and unfortunately some managers, like to take an approach when somebody says racism, religious bigotry, gender bias, whatever. It'll go away. Ignore it. Somebody has a disability, it'll go away. Ignore it. No, that's the worst thing you can do. Don't shy away from the issues. Your primary obligation, the HOA's primary obligation, is to look into these things and document that you did so. Ignoring it is the best way to get really bad liability. Get counsel involved early and often. Respond promptly to all requests for disability accommodations, and consider adopting a fair housing policy. I think we've helped a lot of you guys with getting these policies in place, both in terms of having a process for folks to raise their harassment complaints, and also having a process for responding to the disability accommodation request. That makes it a lot easier for boards to know what on earth it is they're supposed to be doing when these requests come up. So we can help you out with proposals for policies along those lines. Feel free to reach out to us.
Yeah. Yeah, and having a policy in place is also really good to have. If some of you have gone through this process of fair housing, a homeowner files a fair housing complaint or a civil rights department complaint, a HUD complaint, they often ask the association, well, what is your policy to comply with fair housing? And most associations, the response is we have nothing, or we follow the law. Hopefully they could say that, but yeah, having a policy in place will really help, hopefully even avoid those situations. All right, so I know we got a couple of questions in about other topics. Are there questions about this topic before we move on? Christian.
I have a question regarding the pet accommodation. So if the dog is certified, they are a working dog, and the homeowner has them off leash in the common area and claims they are training their dog, but it doesn't appear that they're training them, but because they're a working dog, they need to be able to work with them and train with them in various situations. Like, would you send a violation letter for that?
Not a violation letter, because there may be something more to it. So right before, since they say if you're already aware that they it's a service animal or training, if you're aware of that, I would probably get more information about what they're training for. Or we had a situation where we had that kind of situation, or that kind of animal. They couldn't be on the leash, but the association worked with that owner to kind of figure out a time to walk with their dog through the common area at a time when there's not a lot of other dogs or kids, or other people. So there might be other ways around it. But there are situations where service animals can't be on a leash. That's why it's important to have more information, and ask for it in an appropriate fashion, rather than through a disciplinary hearing, because a lot of times, even if they don't have grounds, their reaction is very defensive, and then they'll start looking for ways to get back at the HOA for doing that. So, yeah, at that early stages, maybe get more information and work with them.
It's helpful too to orient the board to, okay, what's the concern here? Is the concern that this dog is going to hurt someone, or is the concern that neighbors are going to get annoyed that this person's breaking the rules? If it's the latter, then okay, we need to dig into that. Or if it's the former, we need to dig into that. But if the concern is people are going to get annoyed, this person's breaking the rules and I can't break the rules too, we deal with that a fair amount, where we end up having to say some version of, we're not going to get into this person's medical details, but explaining to the rest of the community there are things that we're obligated to do under fair housing law, which means sometimes people get exceptions to those rules. It doesn't apply to everyone. It's because of specific medical situations that we have to deal with. But we do end up dealing with that part of it where we're speaking to the rest of the community in some fashion, or the people that are have their backs up because this person has an exception to the rule.
Yeah. Yeah. And there may be other ways, like I said, to address the board's concerns. Like they may think, well, now other people will think it's okay. So then talk to them if they can have their pet or not pet, animal, their service animal wear a specific vest or collar or something, to, I think in most situations they can, and that kind of helps at least the appearance that they're not just breaking the rules and that anybody can do it and that the association doesn't care.
Thank you.
Yeah. Anybody else? Yeah, Brad.
Thanks, guys. I have a quick scenario that has already been gone to legal counsel for this particular association. Long story short, homeowner has a disability, is asking to use his deeded parking spot, which is in a subterranean parking garage, and use his spot to install and use his physical therapy equipment, which would consist of like a treadmill and a bike machine. And the current position of their legal counsel and the board has been no, not because they're not willing to make the request, but that the subterranean parking garage is not an appropriate facility for that type of workout equipment. There's no outlets. There's no climate control. There, it's open on both ends, so wind and debris can blow in and out and things like that. Would you say for something like this, do we just say, yeah, go ahead and let him suffer when he gets it all installed down there, or?
Yeah, I think
Like
the question. I'm sorry, I didn't mean to cut you off, Brad. Go ahead.
Yeah, go ahead. At what point do we say no? It doesn't make sense to do it there. We're willing to accommodate you, but in a subterranean parking garage is not the place to install it.
I think if that's where you end up, then that's the right approach. I think the first question is, does this cause a problem for the HOA? It being an inappropriate place for this stuff, yeah, I get that, but is it actually causing some sort of problem for the HOA or the other home?
It is not. It does not cause any problems for the HOA.
Yeah, I think the concern is what, carbon monoxide or poisoning or something.
Totally.
Yeah.
I mean, that's where you like the association through your legal counsel, but like, limitation of liability, like you're doing this at your own risk, or, and document suggestions, we're not denying you, but that conversation of maybe there's a more appropriate place for this. I don't know if there is or isn't. But as far as like if the association is concerned about his health or liability, it's going to come back on the association. You can separate, the association can do that through an agreement or covenant that limits their liability.
Awesome.
Yeah.
That's exactly what I was looking for. Thank you so much.
Yeah.